Good morning, everybody. Thank you for joining us for some employee handbook training today. As everybody files in, I'm going to go over a little bit of housekeeping. My name is Stephanie Neely. I'm the marketing director here at California Employers Association. During today's training, we're going to have a lot of polls, so please keep an eye out for those. I'm actually going to launch a quick poll right now. It's just so you can practice a little bit, get a feel for it. This is just asking, what do you hope to learn from today's webinar? Is there anything in particular you're curious about for your employee handbook? Just let us know. We can make sure to cover that as we go about our presentation today. And as you can see, your audio will be muted throughout today's presentation, but there will be lots of opportunities to engage throughout the polls and the chat box. If you have any questions about the content, enter them into the chat box at that time, and we're gonna hold time at the end to answer all your questions as they come through, or after they come through. Your handouts will be dropped into the chat box shortly. You'll see a file to download in the chat. You can click it and it will download directly to your desktop. This webinar will be recorded, and the team at the Workforce Development Board of Alameda County will reach out whenever it's available for playback. Again, our training today is brought to you by the Workforce Development Board of Alameda County. Today, we are also joined by Javier Contreras, who's here to share a little bit more about the resources available to employers like you.
Thank you. Thank you. And I want to thank each and every one of you for being here this morning. My name is Javier Contreras, and I'm the Business Service Representative here with Alameda County Workforce Development Board. And I'd love to touch bases with you. And what does Alameda County Workforce Business Services connect? What do we do? What do we do? We connect employers with resources and sorry about that. Whoa. Um, I'm sorry. Business Services connects employers with no-cost, high-impact solutions to meet workforce needs. We help business recruit, train, and retain talent through customized services. Support, job postings, candidate screening, and hiring events, training programs, on-the-job training, and customized trainings to upskill your workforce, layoff assistance, rapid response services to support businesses working through transition periods, layoffs, and plant closures. Uh, sorry about that. And whether you're scaling up or navigating change, Alameda County Workforce Development Board is your strategy partner for workforce solutions at no cost to you. We look and we want to partner with you, so please give us a call, and if not, we'll reach out to you and help. I also want to thank California Employers Association for this webinar, and especially you for being here this morning. Thank you.
All right, thank you so much, Javier. All right, and now I'd like to introduce our presenter for today. We have Virginia Young here. She's our HR Compliance Director here at CEA. So with that, I'm going to pass it over to you, Virginia.
Thanks, Stephanie, and thank you everyone for joining us this morning. As Stephanie mentioned, we are CEA. We are the voice behind the hotline, one of the HR directors. I have the pleasure of speaking with you when you do call into that. Some of the things we provide our members, in addition to phone support with our HR directors, are a lot of educational materials in the form of fact sheets, guidelines, and employment forms. We do provide trainings as well as on-site consultation, or virtual consultation with members who need additional help. Just so you know, we are not a law firm, and this presentation is educational in nature. It should not be relied on as legal advice. If you do have an issue that is of legal significance to you or to your company, you should consult your own attorney about that. And with those words, let's dive into our tips about employee handbooks. What we are going to cover in our time together this morning are generally what a handbook is and the benefits and risks associated with creating your handbook. We're going to go over essential provisions to have in your handbook, as well as best practices and highly recommended policies. We are going to talk about the importance of reviewing and editing and updating your handbook and how to go about doing that. And hopefully we will provide you with the important information that you need to update your handbook if you already have one, or to create your handbook if you don't. So let's talk about some of the benefits of an employee handbook. And I'm going to start this by telling you that the law does not require that you have an employee handbook. It is something that employers choose to do to help facilitate their human resources function and to help their employees understand what benefits they are going to receive and what your expectations of them are as employees. So the benefit, one of the major benefits of having an employee handbook is that by putting these expectations and benefits in clear guidelines in the form of a handbook, you set a positive tone for your business. Your employees have a clear explanation about benefits and expectations. It shows that you are on top of things, that you're caring, that you care about their experience. It makes them feel more comfortable with you as an employer in general, and it may help avoid it may help them feel comfortable and not seek additional representation, such as a union. Another major benefit of employee handbooks is that it can provide a valuable defense in the event of legal problems. For example, your handbook is the ideal place to confirm the at-will nature of employment, which we'll go over in more detail in a couple of slides. And it also can help defend your company, showing your practices with respect to harassment and even some wage and hour claims. Finally, having a clear handbook it provides uniformity and consistency in your practices. It's easy for your managers to know what they're supposed to do and how they're supposed to respond to situations, as well as providing guidance for your HR staff and for your employees. Lack of uniformity and inconsistency in a workplace is typically the source of discord, complaints, and unfortunately, eventually lawsuits. So a handbook can help with all of these things if you do it right. And in that regard, what should you avoid when creating your handbook? Well, the first big caveat is that there's nothing worse than creating a handbook but not following it. This is a big problem because your handbook, you're essentially writing down what you're going to do, and then if you say you're going to do something and then you don't do it, that can raise issues on a lot of fronts. Contract-based claims, claims of inconsistent treatment, all sorts of problems. So make sure you're going to follow what you put in your handbook first and foremost. A second issue that you need to avoid with handbooks is having a handbook that you haven't really reviewed or tailored to your company, or a handbook that isn't updated regularly. So to the first point, if you just pull a handbook off the internet or borrow a copy from someone else and you don't review it to make sure that it is up to date and compliant with the laws that apply to your company, and make sure that it is consistent, I'm sorry, with your practices and policies, you run the risk of not having something that truly reflects your business, that creates promises and expectations of employees that you aren't complying with. So that creates problems in and of itself. I have actually seen handbooks doing if have the name that is the employer. So all of those are issues. If you're going to do your handbook, you need to make sure you're going to update, review, and make sure it's tailored to your company. So how do you go about creating your employee handbook? It really depends. If you have a handbook already, you should take time to look at it, reflect on what's in it, and ask accurately reflecting what you do? Is your vacation the same? Is what you're giving people in vacation the same as what your handbook says? Um, are your recognized holidays the same? Are you doing sick leave the way you say you're doing it in your handbook? Are there any rules or requirements that you're not actually enforcing or that have changed? So the first thing to do in that case, review your existing handbook. And then I suggest that you use a professional questionnaire from an HR professional to help you identify areas that may be missing in your handbook, such as certain leaves of absence policies or policies reflecting new laws that have come into effect recently, maybe since your handbook was drafted. There are certain leaves of absence requirements in California that have come into effect just in the last few years that may not be in an older existing handbook. If you don't have a handbook, you would want to start right away with that professional questionnaire to identify what your practices are, and then you can work to tailor a model or template handbook to fit those practices. The ideal handbook, once you're finished with it, has policies that are carefully and clearly worded, that accurately reflect your policy, that are consistent with the legal requirements that apply to you, and that can be understood by your employees. There is some language, some policies are going to have to be longer than others or more wordy than others. But in general, you want to keep it simple. You want all your employees to be able to understand it because this is going to be where they go to answer common questions. And our last point, you don't want your handbook to be boring. This may sound like an impossible task, but it is, and you're probably not going to have a handbook that's going to make the New York Times bestseller list, but you can make it engaging. A lot of employers put photos and things like that into their handbook or graphics to help keep it more interesting for employees. But in sum, you want to strike a balance between giving all the information that is necessary for employees and making it understandable. So let's talk a little bit. And did we have a brief poll about how many people have handbooks and how many don't? Oh, I see that's up. And it's looking like a lot of you have, we've had one reply and you have a handbook. So that's cool. If everyone else, if you don't already have a handbook, now is a good time to think about it and get started. And I can see the person who does have a handbook is getting ready to update theirs. So let's talk briefly about the difference between a handbook and a policy manual. We often get these questions here. A handbook is a generally, it provides abbreviated coverage of all of your generally applicable policies that apply to everyone. As I mentioned just now, it is for everyone to be able to read and understand. A policy manual, on the other hand, is something that you're writing for to give the manager or supervisor in charge of that function detailed coverage or information about how to do their job, what procedures you're going to use. It would include forms, things like that, how you're going to address vacation requests, things like that. A policy manual would generally not be given to employees. It would be for the use only of the employee who is in charge of that particular procedure. Sometimes policy manuals, again, they're not required. Sometimes they get very long, hundreds and hundreds of pages. If you're going to do a policy manual, you want to consider that just like a handbook, it's going to be, it's going to be available if there's later litigation, just like your handbook would be. So you want to give some thought about the length of your policy manual, what's in it, and who it's intended for. So let's switch to the essentials of employee handbook. We've all decided we're going to do one or update ours. And the basics are making it simple, as I've mentioned, putting in policies that are absolutely required, and deciding what policies are really a best practice to protect your company. You're also going to want to consider that your handbook should be a place that employees can turn to answer some basic questions such as these. Um, you know, can my job duties be changed at all? How much notice do I have to give before I resign? Where do I go and how do I report it if someone in the office is making me feel uncomfortable? Um, what are my protected leaves? If I have a medical situation, do I have any protected leave that I am allowed to take? Do I get any paid leave other than paid sick leave, such as holidays or vacation? And what are the rules I have to follow about my meal and rest breaks? What if I just don't want them? So your employees should be able to go to your handbook and answer all of these types of questions. There are some very important statements in handbooks that you want to have, and these may seem like legalese, but they do serve an important purpose. You want to make sure that you tell that your handbook says that you can change the terms and conditions of employment, meaning termination, demotion, transfer, without advance notice or cause. This is affirmation of the at-will status of employment that I mentioned earlier, which is it is presumed that employees and employers can end the employment relationship without notice or cause. You want to reaffirm this in your handbook because employees often argue that a supervisor or someone else at the company has changed that and promised them that they will only be fired for certain reasons or that they will be employed for a specific period of time. You want your handbook to sort of negate the ability of other employees or supervisors or managers to change the at-will status of your employees. And along that line, you do want to say that at-will status cannot change by any employee except for one very high-level employee in the company, such as the CEO or the president, and that any change from at-will status has to be in writing. So these two statements together are a very good, solid way to reaffirm your at-will status of employment in a way that can't be arguably changed in day-to-day operations. You also want to include what is called an integration clause, and this is basically a statement that says this handbook is our rule and it supersedes all prior policies or handbooks covering the same topic. You don't want your employee coming to you with a vacation policy from 25 years ago and saying that this was never canceled or superseded. You want to make sure that your handbook indicates that it reflects current policies and replaces the ones that went before it. There are some must-haves in handbooks. You must have a policy on prevention of harassment, discrimination, and retaliation. In general, those policies say that you make employment decisions based on work-related factors, and that you do not tolerate harassment based on any protected category or classification, and that you don't retaliate against employees who make complaints about discrimination or harassment. There are a lot of specific requirements that must go into your harassment and prevention policy. Our model policy, we've tried to make it as straightforward as possible. It's still a page and a half long. So we will give you the basics of what need to go in the policy, but it is a really important policy. It's going to be one of your longer policies in your handbook. And it has some very specific requirements. The first one is to list all of the protected classes under California's Fair Employment and Housing Act. And there are all, I believe it's 20, it might be 19. These are all of the currently protected classes under FEHA that need to be listed specifically in your harassment prevention policy. The most recent ones we've added are reproductive health choices and off-duty cannabis use. Those were just in the last few years. So this is another reason to update your handbook because your list of protected classes may change as the law changes. Other requirements for your harassment and prevention policy include statements that harassment is illegal and will not be tolerated, that harassment is prohibited regardless of whether it's a coworker, a third party, or a supervisor engaging in the conduct. You need to include an anti-retaliation statement for employees who in good faith complain about harassment or discrimination, or who participate in agency or investigations or in company investigations. And you will need to include some information relating to the harassment prevention training links for the California Civil Rights Department and the EEOC. Finally, your harassment prevention policy needs to have a detailed complaint process for employees to follow. And within that complaint process, you have to inform employees that you will keep information confidential to the extent possible, but that you cannot fully guarantee confidentiality. And you also have to provide that the company will timely respond to the complainant, conduct an impartial and timely investigation, including documentation and tracking for reasonable progress of the investigation. You do need to indicate that remedial action will be taken in the event harassment or discrimination is found to have occurred. And you have to promise timely closure of your investigations. So you do need to have this complaint process. It needs to be pretty detailed as part of your harassment policy. If you do have more than 10% of your employees speaking a language other than English, your policy has to be translated into that language. So it's a good idea to translate your whole handbook, but certainly that that harassment and prevention policy must be translated. Okay, I'll just take a brief second and look at the chat and see if we have any questions so far. Stephanie, do we have anything, any specific questions in the chat that you can see at the
It
moment?
looks like you are answering everything beautifully. We haven't had any additional questions come in, so
Okay.
I think people are getting their questions answered as you go. And just a reminder to everybody, if you throw your questions in the chat box, we are going to make sure we have some time at the end of this presentation to go over those with you as well.
Great. Thank you, Stephanie. I appreciate it. Okay, so we talked about harassment, prevention, discrimination. That's your one big required policy that you have to have in your handbook. And even if you don't have a handbook, you have to have that policy in writing and distribute it to your employees. So it's really not optional under any circumstances. The second part of your handbook that really requires that you need to consider are leaves of absence. California has many protected leave of absence laws. Some of them do require you, if you have a handbook, to include those laws in your handbook, and I will flag those as we go through this section of the presentation. But we do recommend that for any protected leave of absence laws that apply to your organization, you really mention those in your handbook, both so that employees understand their rights to ask for the leave, and so that your HR staff knows how to recognize when an employee is seeking an absence for a reason that may be protected by law. It helps everybody to lay them out in your handbook, is my point. So a paid sick leave policy it's not technically required that you have it as a written policy, but I would say that it is pretty difficult, if not impossible, to comply with the paid sick leave law without having your policy written down somewhere. So I would consider this pretty mandatory, at least from my perspective. As you're all probably aware, California's paid sick leave law, it actually has been around since 2015. It just turned 10. We've had it in place for 10 years now. Still generates a lot of questions and confusion for employers. In general, it provides for 5 days or 40 hours of sick leave that is job protected for all employees to address their own health needs or the health needs of their family. We could spend a whole hour talking about paid sick leave. I'm just going to give a brief few minute overview of this so to give you a little more clarity on why it's so important to have it as part of your handbook. So employers have to choose how they provide paid sick leave, and they have to provide it in a way that is permitted under the law. The sick leave law gives a few different options for employers. You need to pick an option and comply with all of the requirements that are associated with that option. The first option is an accrual method where employees accrue paid sick leave for as they work at a minimum rate of 1 hour per every 30 hours worked. They are accruing time. It does not go away at the end of the year if they haven't used it. It carries over, but you can cap the amount of sick leave an employee can have accrued in their bank at 80 hours or 10 days, whichever is greater. So once an employee hits that cap, they don't continue to earn the paid sick leave until they use paid sick leave and fall below it. This is what keeps you from having really big paid sick leave balances to deal with. You can also limit employees' use of paid sick leave to 40 hours or 5 days a year. Just as an aside, you may be asking why we say 40 hours or 5 days. That's because if an employee has a 10-hour day, like maybe you have an alternative work week, or maybe you just pay them a lot of overtime. If they have a 10-hour day, 5 days is 50 hours. Okay. And if they have a 6-hour day, you go with the 40-hour minimum. That's what that means. And that's why you see so much of the paid sick leave law phrased that way. So the other option is a lump sum method. You can provide the 5 days or 40 hours every year as a lump sum at the beginning of the year. And at the end of the year, unused time goes away and you reload the bank. This is very popular for ease of administration. It may not be such a great deal if you have a lot of part-time employees because you have to give everybody a minimum of the greater of 5 days or 40 hours. So it's your choice how you do it, but you have to pick a way. You can also provide your paid sick leave through a PTO plan, which combines paid sick leave and vacation. But when you do that, your PTO plan has to comply with all of the sick leave law rules and all of the vacation law rules at the same time. So this can make it a little more complicated. And it does mean that you will have to pay out unused PTO time at the end of employment. Okay, so I'll just say that again. If you combine your sick leave into a PTO plan where employees, it's vacation and sick leave are lumped together in one bank, that means all of it is payable on termination of employment. Okay, in general, a separate sick leave policy that may be used only for sick leave does not need to be paid out at termination. So that's a big difference to consider if you're thinking about having a PTO plan. Under any of these plans, you can require new hires to wait until the 90th day of employment to use their paid sick leave or their PTO in that, if you choose that. And the paid sick leave law contains very hefty anti-retaliation provisions for employees who use their sick leave, have questions or complaints about sick leave, are protected from retaliation. So you need to be aware of that. You also need to be aware that if you are in certain cities, they may have local sick leave ordinances that are more beneficial to employees than the state law, if you can imagine. And in that case, if you have employees covered by these local sick leave ordinances, you have to provide them with the higher benefit. The cities to be aware of are in the Bay Area: Berkeley, Emeryville, Oakland, San Francisco. I think that's it. Berkeley, Emeryville, Oakland, San Francisco. Yes. And in Southern California, Los Angeles City, San Diego, and Santa Monica all have sick leave ordinances. We do keep track of which cities have these ordinances, along with local minimum wages. And at this bit.ly link, you can access our chart that we update every July and every January to reflect increases and new developments. Okay, so we went over sick leave. You really do need to have a policy in your handbook for that. Another kind of protected leave that you would need to have in your handbook is a pregnancy disability leave. If you regularly employ 5 or more employees, your employees, you'll be covered by the pregnancy disability leave law, and that means your employees will be eligible for pregnancy disability leave when a healthcare provider certifies that they cannot perform one or more essential functions of their job without undue risk to themselves or their pregnancy. Um, there is no eligibility, there is no length of service or hours of work requirement to be eligible for pregnancy disability leave. You can have an employee go out on pregnancy disability leave on their first day of work. They are still eligible. And I actually do see that pretty often. And you should know that pregnancy disability leave can occur during any time during the pregnancy, before, during, or after. It really depends on what that healthcare provider is going to certify relating to the specific patient. So it's important to have a pregnancy disability leave policy in your handbook. The amount of pregnancy disability leave is up to 4 months, which means the amount of time an employee would work in the course of 4 months. It's important to know that the amount of leave is per pregnancy and not per year. So it is possible for an employee to take 4 months of pregnancy disability leave, come back for a couple of months, and then go out on pregnancy disability leave again, for example, if she has another pregnancy and complications associated with that. So it is per pregnancy, not a per year leave entitlement. It can be used all at once, they're off work completely, or it can be used intermittently in increments of as small as 1 hour. But again, how she uses the leave, or how the employee uses the leave, depends on what the healthcare provider certifies. You cannot require employees to use their vacation or PTO during this leave, but the employee can choose to do so if they want. The time needed, again, the time needed and how it's taken has to be certified by the healthcare provider. So this is a lot of details for pregnancy disability leave, and this is one reason you really need a policy so that employees know what to expect, and so your HR team knows how to administer the leave. Another type of leave that is going to apply to your employees if you have 5 or more employees is California's Family Rights Act leave, or CFRA. If you are covered by CFRA, if you have 5 or more employees, you are and you have an employee handbook, you are required to address CFRA in your handbook. CFRA provides just a brief overview: 12 weeks of unpaid leave with group insurance benefits to any employee of a covered employer who has worked for 12 months and has worked 1,250 hours in the 12 months just prior to leave. And that 1,250 hours is roughly 60%. Like an employee, like a 60% employee is going to hit 1,250 hours most likely. The reasons for CFRA leave are for baby bonding, for the employee's own serious health condition, except for pregnancy. That is treated separately under the pregnancy disability law that we just covered. Or it can be used to care for a family member who has a serious health condition, and this extends to spouses, including registered domestic partners, parents and in-laws, siblings, grandparents, and grandchildren. It also applies when an employee has when an employee can designate a person for whose care they want to be able to use their CFRA leave, and there doesn't have to necessarily be a family relationship. Employees can be limited to identifying one designated person per year. And finally, CFRA leave does apply to certain military circumstances when your employee's spouse, child, or parent is being called up to emergency active duty to be deployed to a foreign country. So you do need to have a CFRA policy in your handbook. And again, like pregnancy disability leave, it's a complicated and technical law. And for that reason, you want it addressed in your handbook so that people have information about it. It makes administration a lot smoother. If you have 50 employees, you will be covered by the Federal Family Medical Leave Act, which is very similar in a lot of ways to CFRA, with the 12 weeks of unpaid leave in a 12-month period. Employees have an additional eligibility requirement, which is that they work at a location with 50 or more employees within a 75-mile radius. That is not an eligibility requirement under CFRA, but it is under FMLA. And if you are covered by FMLA, you are also probably covered by CFRA, and you need to consider their leave under both laws. You do have to have a handbook policy relating to FMLA if you are FMLA covered employer. In connection with the policy that you have to have if you are a FMLA or CFRA covered employer, you need to establish your 12-month period in your handbook. What does 12 months mean? Is it a calendar year? Is it anniversary date? FMLA and CFRA give you specific choices of how you calculate your 12-month period. You have 4 choices. It can be a calendar year, another fixed period like June 1st to July, or July 1st to June 30th. It can be your fiscal year, or other fixed 12-month period. You can also use a look forward method where you say, all right, this employee went out on April 1st, was his first day of leave. So his year starts, it's April 1st to March 31st. Or you can use a look back method, also called a rolling method, where you keep looking back over the previous 12 months to determine whether the full 12 weeks has been exhausted. It's your choice which of these you pick, but you have to pick one and stick with it for all employees. If you don't do that, then you will have to determine which method gives the employee the best advantage each time, which, as you can imagine, doesn't make a lot of sense and is extremely difficult to administer. Okay, there are some more protected leaves that you need to be aware of, and whether or not they apply to you really depends on how many employees you have. If you have some of them apply to all employers, such as jury duty and voting leave. Some apply only when you have 5 employees, such as bereavement and reproductive loss leave. Some apply when you have, and I think I said that wrong. Some apply it to everyone. Bereavement and reproductive loss leave apply when you have 5 or more, just to be clear. Some apply when you have 15 or more, such as bone marrow or organ donation. Others don't apply until you have 25 employees, such as drug and alcohol rehabilitation and military spouse leaves. These are all distinct leaves of absence. They all have their own laws that describe their unique requirements, but if you are covered by these laws, you want to address them in your handbook to make sure that employees get what is due. So moving on from leaves of absence, and I'll just ask Stephanie really quickly if we have any leaves of absence questions in the chat.
We don't have any right now, but I will keep my eye out because I know this is one of our most common asked about topics.
Yes, or feel free to call us on the HR on the hotline if you do have specific questions, but very important to a part of your employee handbook, that's for sure. Okay, so let's move on to wage and hour. There are some important wage and hour policies that you really need to include in your handbook, and you guys may have heard of one good reason to have a good wage and hour section is that having strong wage and hour policies and practices that you train your supervisors on can help minimize your liability in the event of a PAGA claim. And that is the topic of another webinar itself, but PAGA was recently reformed, and one of to allow for certain efforts by employer, or reasonable efforts to comply with the law to reduce their PAGA liability. And having strong wage and hour policies are a component of that. So just to remind you of why it's important. So it's important that your handbook define your work day and your work week. A work day is a 24-hour period. Midnight to 11:59 p.m. Is a work day. Maybe you can define it however you want within those hours. And a work week would be a 7 consecutive day period starting at the same day each week. The reason that you need to define the workday and the work week is because that's how you trigger your overtime premium. So just as a reminder, you guys may already know this, but in California, non-exempt employees get overtime over 8 hours in a work day, over 40 hours in a work week, and on the first 8 hours on the seventh day in a work week. It's a sorry. So in all of these, there are definite, the words workday or work week appear in all of these bullets here. And that's because it's your definition of the workday that decides when an employee has worked more than 8 hours. If your workday begins at 3 p.m. and ends at 2:59 p.m., that's the period of time you're going to look at to calculate your workday. If you do not define a workday and a work week, the state will consider the workday to begin at midnight and end at 11:59 p.m. and it will consider your work week to begin on Sunday and end on Saturday. So if your business, if that just really isn't your real work week and you want to define it differently for everybody, your handbook would be the place to do that. Again, you would have to make the workday and work week consistent. You can't just move it around all the time, but you can adjust it and set it on a permanent basis to fit your business. And just a note about minors and overtime. It is a misdemeanor to require a minor to work overtime, even if you're paying them overtime. So if you do hire minors, that should be addressed in your handbook, that minors cannot work overtime no matter what. Meal and rest break periods are a critical part of an employee handbook. They are not technically required, but they fall into the camp of something that can really that are really important to defending you if you face a claim, usually brought on a class-wide basis, for meal and rest break periods. If you have a compliant written policy, that is really critical to defense in those cases. And if so, I would say it's like sick leave. It's more or less mandatory, just from a protection kind of standpoint. Meal and rest break claims continue to be very costly for employers across the state of California. So you're going to want a section that sets forth your meal period policy and your break policy. Again, these apply to your non-exempt employees. And you do want to train your managers to strictly follow this policy because, again, that is part of what's required to show your reasonable efforts to comply with the law, as I just mentioned, for mitigating PAGA liability. It's also really the only way it's going to get done correctly is if you train your managers to strictly follow your policy and they know what's in it. So just a really quick refresher. Rest breaks, you're required as an employer to authorize and permit a 10-minute paid rest break for every 4 hours worked or major fraction thereof. What does major fraction of 4 hours mean? Well, the California Supreme Court figured it out for all of us, and this is the chart it means that they came up with. So an employee who works fewer than 3.5 hours doesn't get any rest breaks, but beyond that, basically it's 2 hours is considered the major fraction, and if they work your regular 8-hour day, they're going to get 2 paid rest periods. Whereas if they work fewer than 6, they are only going to get 1 paid rest period. In general, rest periods should be taken in the middle of the work period, but there's not a specific timing requirement. You do not have to record your rest periods on time cards. You may not require employees to remain on the premises during rest breaks. That was a change in the law several years ago. You used to be allowed to require them to stay on the premises. So that is not the law anymore. You cannot require them to remain on the premises, and that should be something in your handbook. So if your employee wants to go to Starbucks and get back to their desk in their 10-minute rest break, then you have to let them try. Does not mean that you can't discipline them for not getting back to their workstation on time. If you do not provide a work break, or I'm sorry, a rest break in any day, the employee will be entitled to a 1 hour of additional pay as a penalty, and this is paid at their regular rate of pay. So whether they miss one break or two breaks during the day, you still just pay the 1 hour for rest breaks. Meal breaks are a little bit different. You want a separate policy about meal breaks. That's a 30-minute required unpaid meal break if they work more than 5 hours of the day in the day, and second unpaid meal break of 30 minutes if they work more than 10 hours in the day. Unlike rest breaks, meal periods are unpaid. The start and stop times have to be recorded on their time cards, and there are strict timing requirements for the beginning of the meal break. So the first meal break has to begin before the end of the 5th hour of work. That means when your employee clocks in, by the time the time clock hits 4 hours and 55 minutes and 59 minutes, they need to have started their first meal break. It's by the end of the 10th hour of work for the second meal break. They need to be relieved of all their job duties. They have to be able to leave the premises. And if there is any missed meal break in the day, you owe that 1 hour penalty. Some things are common between meal and rest breaks, and you want to make sure these are both, all these points are in both your meal and rest break policies. One, that employees can leave the premises for both. That they must return to their workstation promptly. If that Starbucks line is really too long and they just can't make it back in time, that's on them. They can still be disciplined for not getting back in time. You also want your policy to require them to notify their supervisor and document anytime they miss a break and the reason why. And the reason you want to require employees to do this is because it's your duty to provide the break. And if the reason people are starting their breaks late or missing their breaks is because they're being provided, but the employee is just, not complying with your policy and taking the break, that's one thing. If your supervisor is not giving them a break, then that's another thing. Then you're not providing the break. You do want to treat employees who refuse to follow your break policy. That's not okay to allow that to happen. If an employee keeps choosing just to skip their break, you want to treat that as a disciplinary issue and tell them they have to follow the policy, just as an aside. So another caution with meal and rest breaks is meal break timing is very specific, and it cannot be based on rounded time entries. So the California Supreme Court has ruled that you cannot use rounding in determining whether a person's meal break started on time or was the required length of 30 minutes. So if you are using rounding for meal breaks, that is definitely a practice to discontinue. The California Supreme Court is also addressing rounding in general with respect to hours worked, and we're likely to see an opinion from them in the next year. So there is some likelihood that rounding of time entries in general beyond meal breaks may also be a practice that absolutely needs to be discontinued. We don't recommend rounding in general anymore for that reason. Okay, so that's the wage and hour that you want to cover. You also want to cover workplace benefits and expectations, which is what your employee expects to get from you, and your expectations of them relating to conduct. Vacation is the biggest benefit that employers provide to employees that needs to be addressed in your handbook in detail. Employees vacation, it's not required. You don't, unless you have a collective bargaining agreement or are working on a certain federal contract, you're not going to be required to provide vacation. But if you do, you have to follow a lot of rules. And basically, vacation is wages. It can't be forfeited or taken away at any time, meaning no use it or lose it policies are allowed. It has to be paid out at termination. And you need to be aware, this all needs to be spelled out in your policy. You also, to avoid that big bank of time accumulating because it can't be forfeited at the end of the year, you will want to set a reasonable cap on your vacation so that employees don't accrue vacation and not use it for 10 years and wind up with a giant bank of time that you have to pay out. A reasonable cap is usually 1.5 times the employee's annual entitlement. Do watch out for personal days and floating holidays. Those are considered vacation. If it's a day that an employee can choose to take off during the year and they can request it in March or in June or in December or whenever they feel like it, that's vacation, and that's going to be subject to all of these rules. As far as conduct goes, drug-free workplace policies are required for some employers, such as federal or state contractors or grantees, or for employers of DOT-covered drivers. But it's recommended for all employers. There is no law that precludes a private employer from taking disciplinary action against an employee who is under the influence of drugs, illegal drugs, or alcohol at work. So you want to, if that's something most employers want to avoid for safety reasons. And a drug-free workplace policy is critical to informing employees of your expectations, and also to letting employees know that if you are impaired at work, you are behaving in a way that gives you reasonable suspicion that they are impaired, that you can perform a reasonable suspicion drug test. Again, this is something you'd have to inform employees about at the beginning, and your policy would be the place where you do that. Again, random testing is not allowed in California, except for certain like DOT drivers or situations where it's required by law. We mentioned cannabis use rights, which is the new protected class, has caused some confusion. You can't discriminate against employees for their off-duty use of cannabis, but again, like other drugs and alcohol, this does not mean that you have to allow an employee to use or possess or be impaired by cannabis while on the job. There are some exceptions to the protections for cannabis use rights in the building and construction trades, or when testing is required by federal or state law. That is also something that would be addressed as part of your drug and alcohol-free workplace policy. Disciplinary guidelines, what conduct you expect from employees. We suggest that you present discipline as a guideline rather than required progressive steps, and that you reiterate that disciplinary action, violation of company policy, whether it's written or otherwise, can result in disciplinary action up to including termination of employment. You want to allow yourself the ability to take different disciplinary measures depending on the circumstances, the violation at issue. So when you are discussing your disciplinary policies, you want to reiterate that employment is at will, and that any disciplinary action you choose to take, such as a warning, does not change that. There are a number of integrity policies that you will want to consider having in your handbook. We are running a little short on time, so I'll just mention these, and you can certainly call the hotline. I believe that if you use our employee template, our DIY handbook, you would be able to see examples of all of these types of policies. But just to touch on policies that I haven't talked about before, you would want to have a policy addressing workplace violence. You would want to have a policy addressing employees' use of your email or other electronic communication systems. And you'd want to have a policy about employees' solicitation during working hours, the employee who's asking, trying to raise money or sell Girl Scout cookies to other people while they're doing their job. Policies like that are ones that you should consider for your handbook to define your expectations and put employees on notice of what behaviors are going to be unacceptable in your workplace. You may want to also address limit your social media account use to only certain employees and address that in your handbook. You may want to address employee use of their cellular phones or devices while they're at work. That is okay, but you do have to allow employees to use their mobile devices for emergency circumstances. You also, we talked about meal and rest break periods. You do want to talk about, if you're giving employees your property, you do want to have policies addressing how they use it and your expectations in that regard, including the requirement that they return it when employment ends. There was a recent decision, not so recent anymore, where the National Labor Relations Board adopted a very strict standard for considering workplace rules that were argued to be in violation of employees' rights to discuss and work together to improve their wages and terms and conditions of employment. Basically, this decision pushed a lot of scrutiny on workplace rules and put the burden on the employer to show that they really had legitimate business reasons for the rules to be in place. So I skipped a slide there. Types of policies that are at sort of risk of this kind of claim are like restrictions on employee communications, including their social media, confidentiality type policies restricting behaviors for using their cameras, things like that. Those are all at risk of being challenged as violating this right to discuss their wages and terms and conditions of employment. So just be aware of that. Let's see. You don't want to include probationary periods in your handbook. They make employees, the use of the word probationary makes employees think that the at-will nature of employment is somehow different during and after the probationary period. It really doesn't have a legal significance. We would suggest maybe calling it an introductory period or something like that, so there's no confusion about what it means. We talked about lockstep disciplinary procedures. You also don't want to you want to review your handbook carefully for any policies that imply an obligation to keep employees employed for a certain period of time. You're going to want to mention the at-will statement definitely at least once in your policy, maybe a few times. We don't recommend that you provide details of your benefit plans in your handbook. Those change all the time, and you don't need to provide pre-employment practices in your handbook. Your handbook doesn't go to your applicants. It should only go to your employees once they're hired. You might want to consider an employee action hotline as another way for employees to report concerns. It allows you to get on top of things faster sometimes than other channels. This is kind of a checklist going over things that we talked about before, but in the interest of having a little bit of time for your questions, I'll skip over this, but do feel free to ask a question. Just a couple reminders, review your handbook, make sure it's right before you distribute it. You can distribute it however you want, electronically or by paper, a paper copy, but do get signed acknowledgements back. Follow your handbook and train your managers on it. Remember that your handbook does not replace your poster requirement or your safety-related programs. Those are separate requirements. Your IIPP and your workplace violence prevention plan are separate. I will turn it over to see if we have any questions that I can answer at this moment. I have a couple of minutes.
Hey there, Virginia. Thank you. You did a great job. That was a lot of information to go over. So I have another poll launched with a short answer field in there for you guys. We're asking, how do you plan on using the information you learned today? Just so we can make sure you got some practical guidance, you've got some next steps in mind, and we're just providing the most information we can for you guys. And thank you for bringing up this slide. For anybody that thinks they might need a little bit of extra help, we have CEA memberships available starting at the associate level for just under $1,400 a year. There's also a monthly option if you just want to test it out for a few months before you commit to a full year. So be sure to take a look at those. All right, and for those of you looking for your continuing education credits, we've got HRCI and SHRM codes available for you. I'm going to put them in the chat box as well as read them out loud for you. Here we go. All right, for your HRCI code, it's 716423, and your SHRM code is 25-3MSSR. So again, that's if you're looking for your HR continuing education codes. Typically, it's for HR professionals looking for accreditation. All right. And we've got a couple more polls for you. Bear with us. Again, just a reminder, this was brought to you by the Alameda County Workforce Development Board. They have so many great resources for you. Javier went over a lot of those at the beginning. Um, we're wondering, what topics are you most interested in for future presentations? We love getting your feedback on here to make sure we're providing you with the most complete trainings that you want to really benefit your workplace. What's happening? We've got a Form I-9 audit presentations, we've got wage and hour, we've got emotional intelligence presentations. We've got just about everything under the sun. So what would you like to see for your next presentation? Just type that into the box over there. And it looks like we also have a free DIY business handbook flyer that Alameda is providing for us. Um, Let me get that ready for you guys, and I'll pop that into the chat box for you. Okay. Nope, 1 second. Sorry, my computer's just being a little bit slow today. All right, I'm going to go ahead and end that poll, and then we have one more poll for you guys. And this is our satisfaction poll. Let us know how we did. Scale 0 to 5. 0 meaning you didn't learn that much, 5 meaning you learned a lot. We would love to see what you thought of today's presentation. Um, Let us know how we're doing. This helps us serve you better in the future. All right. So with that, I'm going to I'm unfortunately having a little bit of technical difficulties with the free DIY business handbook flyer that was sent out from Darlene. So we'll make sure you guys get that in a follow-up email, along with a copy of the handouts to make sure you have all the resources from this event. And just a reminder too, this was recorded. It's going to be provided to you by Alameda County at a later date. They will reach out whenever it is available for you guys to watch. Thank you so much, everybody. Have a wonderful rest of your day.